Rules Committee will come to order, and thank you very much. Welcome back to all of our members and our staff. Today we are meeting to consider two important pieces of legislation, H.R. 3865, the Stop Targeting of Political Beliefs by the IRS Act, and H.R. 2408, the ALERT Act. First, the committee will consider H.R. 3865, which prevents the IRS from adopting a regulation that would allow it to strip nonprofit groups of their 501c4 exempt status, which is a very important issue, I believe, all across America. And while the administration may disagree with these conservative groups, there is no reason to destroy their ability to engage in constitutionally protected debate. This bill delays for 1 year a proposed regulation so that the Ways and Means Committee of the House of Representatives can complete its investigation on the IRS targeting scandal that came to light last June. I continue to be disappointed as I see the IRS and federal agencies not, in my opinion, adequately to address the debacle which was a part of the last summer. Second measure before us today is a comprehensive regulatory reform bill designed to reduce unnecessary regulations that stifle job creation and economic growth. Americans are asked to foot a hidden bill for regulations, and that bill is staggering. The total regulatory burden at the federal level now reaches an estimated $1.86 trillion per year. Studies have shown that these regulatory costs amount to roughly $7,500 per employee for large businesses and $10,500 for each employee for a small business. These costs are then passed on to consumers in the form of higher prices and less choice. It also helps, it is a disincentive because it competes against a business for being able to have profitability, and so fewer people are employed. Today, Americans need jobs, quite honestly, even in Dallas, Texas, that seems to have a strong economic climate. We need more jobs. And we see the federal government in Dallas, Texas, and across Texas as an inhibitor, a person who is making it more difficult for businesses, small and large businesses, to employ people. The bottom line is the government is competing against the free enterprise system. I want to thank both of the gentlemen that are here today on the first panel, both gentlemen from the Ways and Means Committee, Mr. Bastani from Louisiana, Mr. Levin from Michigan, for bringing their leadership talents not only from the committee and to this Congress before this Rules Committee today, but we also appreciate their testimony and their expert witness ability to be able to help this committee work through the intricacies of this bill and other ideas associated with that. I want to thank both of you for being here, and before I defer to you, I'd like to defer to the gentleman from Massachusetts for any statement he'd like to make. Gentleman's recognized.
Well, thank you, Mr. Chairman. I'll be very brief. I want to welcome the two gentlemen for coming to the committee. Look forward to their testimony, but quite frankly, I would rather be taking testimony on a bill to increase the minimum wage or to deal with the issue of pay equity, because women still on average, get paid less than men do for working the same job. I would wish we would bring a jobs bill to the floor. I wish we would bring a comprehensive immigration reform bill to the floor. You know, that's what my constituents are looking for, the kind of action they're looking for, things that are going to actually not only work their way through the House, but actually work their way through the Senate and get the President to sign these bills into law. So there's a great deal of frustration, Mr. Chairman, with the way the Republicans are running this House and the priorities of the Republican majority. And so I say that not to out of any disrespect to the two gentlemen that are here, and I admire their tenacity and their work ethic here, but there are just a lot of things we should be doing that we're not doing, and I felt I needed to vent that frustration that I heard when I went across my district during this break. I thank the gentleman.
Gentleman yields back his time, and I do appreciate, respect the gentleman. I know he wants higher taxes, higher gasoline taxes, $1 trillion more in spending. for us to have a more activist government that is big and is in all parts of our lives. But that's not what we're going to do today. We are going to do the things that I believe that will help the American people to understand that big government is a problem to freedom and opportunity, not the answer. And with that said, our two leading witnesses today both represent an important and intellectual curiosity and argument. Both of these gentlemen that are before us today are distinguished. Mr. Levin, I'm delighted that you're back today. If you'll please remember, along with Mr. Bustani, that need you to punch the green button or the button there to get the green light on your mic. Without objection, anything you have in writing will be entered to the record. And the gentleman from Louisiana is recognized.
Well, thank you, Mr. Chairman, for holding this hearing. And the legislation, H.R. 3865, before the Rules Committee today prohibits for 1 year, the Treasury Department from finalizing its proposed regulations that would significantly limit the First Amendment rights of 501c4 social welfare organizations. This legislation is supported by the committee's ongoing investigation into the IRS's targeting of conservative groups through political screening, endless delays, and inappropriate information requests. Under regulations in place for over 50 years, an organization is eligible for a tax exemption under Section 501c4 of the Internal Revenue Code if it is primarily engaged in promoting social welfare. Under the proposed rule, however, many 501c4 organizations will find their exempt status in jeopardy. To magnify the unfairness, groups like labor unions would remain completely unaffected. This legislation prohibits the finalization of the proposed rule for 1 year. And this is necessary for 3 reasons. First, the proposed rule is based on the false premise that the current rules cause, quote, confusion at the IRS. Second, the proposed rule would drive citizens and the organizations with which they are constitutionally entitled to associate from the public square. Third, the proposed rule is premature in light of the ongoing congressional investigations and the TIGTA investigation, that is, the Treasury Inspector General for Tax Administration. Let me turn to the first point to go into a little more detail. The proposed rule is based on the false premise that confusion at the IRS caused the targeting of right-leaning groups. The proposed rule says the rule change is necessary due to, quote, confusion for both the public and the IRS in making appropriate Section 501c4 determinations, end quote. This quote is borrowed from the IRS's own hastily written report that was based on no interviews and no real fact-finding. In contrast, the Ways and Means Committee is conducting an investigation that has included reviewing hundreds of thousands of pages of documents and conducting 36 transcribed interviews. The committee's investigation, while still ongoing, has found that IRS employees were not confused in the Cincinnati office about how to process 501c4 applications. In fact, IRS employees processed Tea Party applications without delay and without abusive questions until Washington, D.C. intervened and ordered applications to be held. The problem for frontline IRS employees was not confusion, and the cure is not new regulations. The problem was interference from Washington, D.C., and the cure is a thorough investigation and changes in the agency management. Furthermore, the committee has discovered that Treasury and the IRS were secretly drafting the proposed new regulation as early as 2011, long before the targeting was made public. In fact, this work was done, to quote an email, off-plan. That's to borrow the language from a Treasury Department employee. This means Treasury and the IRS were attempting to shield their work from the sunshine of public scrutiny. The second reason the proposed rule should be postponed is that it drives Americans away from the public square. Currently, social welfare organizations can engage in some political campaign activity so long as the organization is primarily engaged in activities that promote social welfare. Other activities that promote the common good, such as nonpartisan get-out-the-vote efforts, voter registration drives, and candidate forums, are not considered political activity under long-standing law. This proposed rule would change that. Suddenly, organizations, many of which are small organizations that sprung up spontaneously in communities all across America, have relied on settled law based on a regulation that has been unchanged since 1959, and would be told to watch what they say, to get out the vote efforts, to stop voter registration drives, to cancel candidate forums, or jeopardize their exempt status. Adding insult to injury, many of these organizations are the very groups the IRS targeted in recent years. The proposed rule is a real threat to basic freedoms of speech and association, and it is no surprise that groups across the political spectrum, including the American Civil Liberties Union, have come out against this proposed rule. Third, and finally, the proposed rule is premature in light of the ongoing congressional investigations. While the investigation covered a great deal of ground, it remains open in due part to the IRS's refusal to turn over certain documents, including emails of the former director of exempt organizations, Lois Lerner. Rather than pushing forward with a regulation drafted in secret and based on a false premise, the administration should wait until we know the facts. But it will not, so Congress must act. Mr. Chairman, I thank you. I'll be happy to answer any questions. We hope that we can move forward with this to the floor under a closed rule. And with that, I yield back.
I thank the gentleman for his testimony and for his brevity to move this issue. And thank you very much. Gentleman from Michigan, my friend, Mr. Levin, recognized.
Thank you, Mr. Chairman. Let me try to just spell out a few facts. It's going to be difficult to have that kind of a discussion on the floor because I think the purpose of proceeding is clear politically, but let me just talk about the facts. You said, Mr. Chairman, the administration hasn't been aggressive in addressing the issues. As one of those, I was among the first who called for the two people responsible for the way the applications were being handled. I was among the first to call for their departure.
If gentlemen will suspend just one moment, please. I need you, if you can,
to speak in, okay.
Pull that directly at you.
Okay,
and
thanks.
Boy, that helps a lot. And I thank the gentleman. I'm sorry, but it's very difficult for some of the members.
No, for sure.
Especially some of our younger members that are from Texas. The young guy over there. Yeah. Look, Sandy, I'm not going to pick on him today, but
Leanna's never had
there's a
trouble
doctor
hearing.
in the house, and we need him to stay. Thank you very much. Gentlemen,
okay, anyway, look, I was saying I'll try to avoid discussing this politically. Let me just talk about a few of the facts. You said the administration wasn't being aggressive, and I was saying as one of the early people calling for the two who were responsible in terms of supervision for the mishandling of the applications, that they be relieved of duties. I think I have the credibility to say that the administration and the person who took over acting IRS really got on top of this. So to say that there hasn't been an aggressive effort isn't correct. Secondly, the statute originally, it still does, say exclusive for social welfare purposes. That's the statute. For a number of years, it's been interpreted as primary, and that should be understood. The notion there is something secret about this, the TICTA recommendation was this. It recommended, and I quote, to the IRS Chief Counsel and the Department of Treasury, that guidance on how to measure the primary activity, in quotes, of 501c4 social welfare organizations be included for consideration in the Department of the Treasury Priority Guidance Plan. This was a recommendation of the Inspector General, and it was included indeed in the Priority Guidance Plan. So the notion it was secret and that was brought up at a hearing, is a sham. It's a sham. And Mr. Roscoe, one of our colleagues, introduced H.R. 2532 to require the IRS commissioner to implement all of the Inspector General's recommendations. So what's happening here is the IRS is doing what it was told to do and what it needs to do. And let me just briefly indicate what the history of this is. The number of applications for 501c4 went up dramatically in recent years. It almost doubled. And the amount being spent on political spending went up from 1.21 million in 2006 to 256.26 million in 2012. From 1.21 million in 06 to 256.26 million in 2012. The two largest 50C1 entities who are spending for political purposes are Crossroads GPS and Americans for Prosperity. American Crossroads and its social welfare in quotes counterpart, Crossroads GPS, spent between them $176 million in their report to the FEC. Nearly $71 million of that was spent by a 501c4. So the notion that there is nothing to look into is essentially a smokescreen. 501c4 entities should be primarily for social welfare. The statute says exclusively. And so we're not talking mainly in terms of political expenditures by these small entities. That isn't where the money's being spent. Just take a look at the list that comes from opensecrets.org, and I ask that this be put in the record. Mr. Chairman, I ask that this be placed in the record.
That objection, the gentleman's statement be placed and the attachment be placed in the record. Thank you.
Now, no one's saying this regulation is perfect. No one's saying that. And for example, the way it's written, it might well include voter guides that are put together on a nonpartisan basis in my area by the League of Women Voters. I don't think that that likely should be included because I don't think that they are for a partisan political purpose. But there is an issue here. And there should be an issue in the minds of anybody who cares about democratic with a small d functions in this country. The problem with 501c4s, we don't know in many cases, indeed in most, where the money came from. We don't know where the money came from. They avoid disclosure because they're 501c4s. I don't think anybody in this institution really wants more and more money in political campaigns. I don't care whether you're a Republican, Independent, Libertarian, whatever you are, coming from sources that are undisclosed. So there is nothing secret about this regulation. Its constitutionality needs to be worked on. There have been thousands of responses to this regulation, so many so that it's unlikely that it would be issued this year in any event. So what's the purpose of this? I think the purpose of it is clear, and I think, unfortunately, and I close with this, I do think we ought to ask ourselves whether or not this institution is working well and whether there's any chance of trying to rekindle the bipartisan efforts that I was fortunate enough to see many years on this committee, on the Ways and Means Committee, and which often I participated in. What's happening here is kind of poisoning the well, and I think it should stop. I think it should stop. And this makes it worse. Thank you.
Gentleman is evidently complete his testimony. I appreciate that very much. Mr. Bustani, this bill that we have before us is 2.5 pages long.
That's correct.
It is attempting to do one thing.
Simply postpone.
Simply say until we've had an opportunity to complete the investigation.
That's correct.
Are you drawing conclusions? Is this for political purposes, Mr. Bustani?
We want to get to the bottom of what happened at the IRS, and the investigation is not concluded, and until we do so, we can't comment further. I want to follow this investigation to its logical conclusion. We think that the problems at the IRS, which are widely acknowledged by both sides, are real. They're important. They affect every single American. It's an agency which has central involvement in every American's lives. And I think it's really important that the agency come clean, the IRS come clean, that its integrity is restored, its trust, the trust on the part of the American people is restored, and that the agency is shown to administer tax law in an impartial way. And any politicization is completely unacceptable and should be unacceptable to everyone in this country, regardless of your political leanings. And so we're simply asking for this to be postponed for 1 year. Let us complete the investigation. Let TIGTA complete its investigation. The facts will come out, and then we can decide on what reforms are necessary.
Mr. Bustani, Mr. Levin is asking this committee to believe and understand that this is in the best interest of all of us, that we would want to move forward with the rules and regulations that the IRS is wanting to promulgate. I thought you were saying that I don't mean to in any way misuse your words, so I apologize. What I believe that I heard you say was that you believe that we do not want to have any more money thrown into the system, and that the rules which are necessary to be promulgated would be helpful for us to understand more about people who gave money in the system that today is not reported. Yes, sir. I'm not trying to say anything wrong about what you said. I was trying to speak about it.
Look, I never said I don't want any more money in the system.
I'm sorry. I thought you said that no one would want any more money in the system, not a Republican, not a Democrat, not a Libertarian.
It was undisclosed.
That's what I thought. What I was saying,
it was
that
undisclosed.
Would not be disclosed.
Exactly.
Thank you. And Mr. Levin, please, you and I see each other every day. I would not try and twist your words. There's no need for that.
I'm not saying you twisted. Okay. I wanted to
nor even mischaracterize.
I just wanted to be clear. I talked about undisclosed. This is undisclosed money.
So the question to Mr. Bustani is, if we did hear that, would that tend to imply to you that everybody, unions, should be included also if we're going to make that statement?
Well, one of the problems, I think that's true. And I think one of the problems is that this targets many of these small organizations. Yes, there are some large ones, but there are many, many small organizations all across America. And to basically eliminate them from the public square in this debate, I think that encroaches on our First Amendment rights, and it's a serious issue. But I want to address something. Ranking Member Levin, my good friend, has mentioned the TIGTA recommendations in their initial report. And one of them was to provide guidance on how to measure the primary activity. This does not mean eliminating these organizations. And when Tom Barthold, the Chief of Staff to the Joint Committee on Taxation, was asked during a recent markup of this bill, and he was asked this question, so the recommendations from the Inspector General who revealed the targeting in the first place isn't even present in this rule, is that correct? Mr. Barthold's answer to the committee was, you're correct, it does not address the measurement issue. And so I wanted to make that clarification that the nonpartisan Chief of Staff of the Joint Committee on Taxation has said that this rule does not address that TIGTA recommendation.
Well, and I appreciate that. I think that line of question that I was going to go down is, does the rule that the IRS says wish and promulgate, does it offer full disclosure for everybody?
It does not.
Oh, see, that was my point then. So selective?
No.
Selectively trying to say who they, once again, can continue to look at and I believe politically harm. I don't believe it's selective enforcement. I don't believe it's selective at all. I think it's obvious and intentional.
Well,
and
unions could continue in this.
I think it's done on a political
501c3s could continue the same types of activities which are now being prohibited by these 501c4s.
Well, I think it's harassment, and I think it comes directly out of the White House. As we have seen, the investigation's not over the number of times that the IRS commissioner visited the White House.
And I'm deeply disturbed by the fact that work was started on this rule prior to anything becoming public about these allegations with the Tea Party groups. And in an email that Chairman Camp revealed, there was discussion, which included Lois Lerner, that said, we will talk about this off-plan. That's worrisome. And we need to pursue that and understand what exactly was going on between IRS and Treasury and perhaps other entities.
Mr. Chairman, could I just say a word?
Yeah, the gentleman's recognized.
You mentioned the White House.
I did.
There is zero evidence that there was any political intervention in this. That was said by the Inspector General, and it has been said repeatedly thereafter by every objective observer.
Well, I don't think the investigation is over at all.
Oh, but don't, it isn't over, but then say the White House was involved.
Well, I'm not a part of the investigation, but these issues that have happened with the visits to the White House had to have come under some meaning and purpose.
But why, look.
Look, Mr. Levin, I'm entitled to draw my own conclusion.
You are, except it's the wrong conclusion.
Well, but we're pending the we're pending the end of the investigation.
But why do you draw a conclusion about an investigation?
Where I am today, Mr. Levin, I may draw a conclusion pending the rest of the facts. And Mr. Levin, you mentioned the selective enforcement and these the mishandling. What was the status? What is the status of Ms. Lerner? Thanks. I don't know. So you think she was resigned? Yes, sir.
And there were civil service requirements.
Issues.
Because I was once in an administrative position, I know them pretty well. You have to follow the civil service rules. But I think she has resigned, as the acting IRS did. I called for both of them to go.
Well, I think we all remember the things which were reported. I think we all have ideas about what that is, and I look forward to the end of the investigation and I appreciate both of you being here today.
Thank you.
And I'm not excusing you yet, sir. And I want to thank both of you for bringing this testimony here today. Gentlemen, Ms. Fox recognized.
Thank you, Mr. Chairman, and I want to thank our colleagues for being here today, and I particularly want to thank Congressman Bustani for bringing the bill forward. I do think this is something that we need to do. I agree the investigation is ongoing. The President has made statements saying that there's nothing wrong that's gone on. He has drawn conclusions about this, and I think that we need definitely to pursue this before new rules are made. And so I appreciate what you've done and look forward to our passing this bill. And I yield back, Mr. Chairman.
Thank you, gentlemen. Gentleman from Massachusetts recognized.
Thank you, Mr. Chairman. I'd like to ask unanimous consent to insert in the record the statement of administration policy that says that the President was presented with this bill, the senior advisor will recommend that he veto the bill.
That objection be entered to the record.
And I normally the ranking member submits that, but I decided to do it today, again, to kind of highlight my earlier point that there are so many important things that we need to be doing right now, from increasing the minimum wage to dealing with the issues of pay equity to trying to come up with a jobs bill to, comprehensive immigration reform. And we're doing this. And I appreciate the gentleman saying that this is not political, but, that reminds me of that scene from Casablanca where Claude Rains walks into the casino and tells Humphrey Bogart that he's shocked that there's gambling going on here, and then Humphrey Bogart hands him the winnings. I mean, I've watched these hearings. I mean, please, to say that this is not, fueled in large part by politics, it just ignores the obvious. So this is what it is. We're going to do it. Might as well get it through this committee, get on the floor, get it over with. But hopefully, at some point, we're going to start doing some things that really need to be done in this country. And with that, I yield back my time.
Gentleman yields back the time. Gentleman from Utah is recognized.
Thank you. I appreciate that. I can't get out of my mind's eye how much better that movie would have been if they'd actually gone through and had Ronald Reagan starring in it. You're actually right. And I appreciate the testimony you've given, and I think all the testimony so far clearly says that we need some time and more interest to do it. Thank you. Yield back.
Gentleman yields back his time. A gentleman from Oklahoma, Chairman Cole's
Thank you,
recognized.
Mr. Chairman.
Yes,
first of all, I want to thank both of you gentlemen for being here. And this is an issue I've wrestled with, I guess, professionally and personally for a long time. I agree very much with Mr. Levin's remark. We don't need more money that we can't figure out exactly where it came from. I do have concerns about the administration and the use of the IRS. I mean, the IRS itself had concerns. They knew they'd been involved in some activity that was questionable, and Lois Lerner honestly tried to sort of diffuse it even before it became public by acknowledging that they had. I appreciate the administration has cleaned house a little bit over there. I share my opinion's friend, the acting director, seems to me to be doing a good job and trying to get to the bottom of this. But, I think the legislation is appropriate in the sense that since we don't know exactly what happened and we don't know exactly where we are, we shouldn't be rulemaking at this particular point in time. And this is an agency who's probably ought to do a little bit of restoring their own credibility before they engage in this activity. Whether they do it right or wrong, whether their intentions are appropriate or inappropriate, they simply don't have the credibility right now for people not to raise the question, not to be concerned that they're going to be targeted. I'd suggest someday I'd like to step back from all this, because I've watched both parties and multiple individuals over many decades try to manipulate the political finance system to their own advantage. I don't think either party has clean hands in this. I think there's plenty of people that you can question about it. I remember my friends, many years ago, I was ED of the NRCC in '92, and we thought we knew exactly what we could do. We could give you a certain amount of direct financial contributions, about $10,000. We could give you about $60,000 in coordinated. We could give you research and things of that weren't counted against any of that, and that was it. And then in '96, some of our friends at the DCCC said, no, you can actually set up an independent committee outside this committee, ship over the money all the research, not talk to one another, and that's legal. And it just defied my imagination. It stretched law. And frankly, our people said at that point we had more money than they did. So he said, okay, if that's legal, we'll do it too. We don't think it is legal, but if you're going to play that way, we're not going to sit around and wait. So you're getting these tit for tats. And, even some really well-intended legislative and administrative efforts, I think, have backfired here. I think of McCain-Feingold, I think, is one of the great mistakes because it drove a lot of these monies out of the parties where it was accountable and visible and where you could actually get at somebody if they engaged in inappropriate behavior into third-party groups and kind of shadowy fly-by-night groups that appear and disappear in particular election cycles. So we've got a real problem here. I'd suggest you're not in the end going to get rid of the money in politics when you got a federal government spending $3.5 trillion. I mean, that's too big for people not to take an interest in how that money is going to be spent, collected, and what have you. And so, simple rules that require full financing and let it move through the appropriate campaign and party entities seem to me to be the better thing. But I don't expect that to happen anytime soon. And right now, again, I have serious concerns about the credibility of the IRS, even though I would acknowledge that there have been some steps in the right direction. This just waves a red flag to me, and I don't have any belief or confidence, maybe put it a better way, I don't have the confidence that the rulemaking authority will be used in a nonpartisan manner. So I just soon call a halt until we understand what's going on. I doubt that's what's going to occur, but again, my experience in politics is people fight about this a lot, but at the end of the day, neither side ever gets really very far ahead of the other one. Both of them immediately adapt what the other side does if it looks to be successful. And there's plenty of smart lawyers that seem to find exceptions to whatever rules that we write. At this point, I think the administration would be well advised to tread carefully here. I don't think it's to their advantage to be doing a lot of rulemaking here, again, until they've restored the credibility of the institution. Now, I've talked a long time. I'll give either of you an opportunity to respond if you care, or I'll just yield back. Certainly.
No, Mr. Cole, I very much agree with
Mr. Chairman, if you could please pull that.
I very much agree with
much.
a lot of your sentiments. I don't think the administration is plunging ahead. It put out a rule. The Inspector General suggested that this be addressed. And I just think all of us need to step back, because if in the end result we're going to have equal amounts of endless monies, many of which are undisclosed at the source, I think the American people lose out.
I think my friend makes a good point.
So the fact that it's equal, I mean, look, I looked at this list that I put into the record of where the money came from. And they came basically from organizations that are linked to organizations that support candidates, certain candidates of your party. But I would hope if the two leading organizations, and they are by far the largest, they're not by far, they are the largest, were linked to groups that were openly partisan for Democrats, that we would sit down and say there's a problem. There is a problem. Undisclosed money is a problem. And the growth in 501c4s in the last few years has been immense. And having the amount of money start at 1 million and grow in a few years to 256 million, this is what's reported to the FEC, is a real problem for democratic processes. And I think it's a mistake to essentially make this a political football or an effort at a political weapon. And we have sat through these inquiries, and for Ways and Means members, we're the ones entitled to sit in on these discussions that are secure. So I have to be careful what I say. But there has been zero evidence of political involvement in terms of how the way this was handled by the White House. Zero. And the efforts that were made to link it were misguided. And I don't think it's wise to bring a bill to the floor which essentially carries on or might carry on that purpose. It's a mistake. I mean, I talked to John Dingell last night. I'll finish with this. And I think everybody should take seriously what he said. You don't have to agree with every one of his adjectives about this institution. But what he said is something that's sobering, and he said it so beautifully at that ceremony marking his tenure. He didn't talk about himself mainly. He talked about what's happened to this institution that he loves. And so, and I share those sentiments. And I think we just have to have some care, Mr. Chairman, some care, or we're going to so make it so difficult to proceed together that this institution's prestige will go even further down the ladder. And I don't think any of us want that to happen. So I appreciate your giving me this time. And Charlie and I are good friends. And we say that often when we're not. But we are. We talk a lot.
But this time it's true.
We often talk on a bipartisan basis.
Well, just
Anyway,
then I want to give Mr. Bustani a chance to make whatever points he cares to make. But I want to just, for the record, I'm not making any accusations about the White House. I'm really not. I think that's yet to be determined. And when this all came out, I will just say I had a hard time believing that anybody as smart as the political shop at the White House would have been involved in anything like this. I think they would have said, this is penny ante, this is crazy, this is likely to backfire. So I'm going to have to be convinced that, but I do think when you look at the sheer number of groups that were targeted and how disproportionately of one political persuasion they were, that somebody in the agency was certainly involved in making those kinds of decisions. And I don't know if we've got that person or that culture cleaned out, and it may not have been a single individual. And again, that to me just suggests we ought to be awfully slow in letting this agency, operate in a rulemaking way, in this particular manner. I think the legislation's well advised. I think, again, the IRS, which, let's be fair, nobody ever likes the taxing agency in any society. As I recall, the foundation, this country's independence is rooted in revolt against taxes, so Americans are inherently skeptical of that. But this is an agency that, in this area, rightly or wrongly, has lost a lot of credibility. So I think going slow, particularly on the eve of an election, which is where we are right now, would be advisable. Anyway, Mr. Bustani?
Well, I think there's no denying the fact that there are a lot of practices in our, particularly with campaign finance, that are disturbing to all of us. But I think the American people deserve a complete and thorough investigation of this, period. And we have not finished the investigation. We know, we've seen some disturbing facts emerge. One, through the interviews with the employees in Cincinnati, it's clear that they were processing these applications judiciously and fairly quickly until there was intervention from higher up in Washington. And we do know that they were flagged due to media attention, quote. And what is also disturbing to me is that emails emerged between Treasury officials and the then IRS Director of Tax Exempt Organizations, Lois Lerner, that revealed that these potential regulations were being discussed off-plan. And this is before all this broke with the targeting. So those are very disturbing facts. And I think we need to pursue them, and we need a complete and thorough investigation to satisfy the American people. And that should be the concern of all of us, Democrat and Republican. And I think finally I would say that Mr. Barthold, who was the Chief of Staff of the Joint Committee on Taxation, says that this regulation does not address the measurement issue recommended by TIGTA. We have to respect that. And the final point I would make is that I have far too much respect for this institution. And we should not legislate without doing our due diligence and doing our work. And the same holds for the executive branch. They should not be issuing regulations without a complete and thorough justification for those regulations. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Chairman. I yield back. Thank you for your generosity.
Thank you, gentlemen, very much. Gentleman from Georgia recognized.
Thank you, Mr. Chairman. I wish I'd been with you last night, Mr. Levin, when you were talking with Mr. Dingell. Lots of questions I'd like to ask between now and the end of his tenure. And I've got to believe over his 60 years, he's seen a lot of our authority, and by our authority, I mean our constituents' authority, the people's authority, flow right down Pennsylvania Avenue to the White House under a lot of different partisan controls of Congress and a lot of different partisan controls of the White House. My question for you is this. You joined the Ways and Means Committee when? 1987?
I'm sorry. We're becoming informal, which I enjoy. 1987.
1987. In all of those years on the Ways and Means Committee, doing oversight under Republicans and Democrats, has the committee ever moved legislation to try to address that 1959 IRS interpretation of the statute?
No, the reason I think is is related to what I said, because there wasn't much use of it for political spending. In 2006, 1.21 million. It was minuscule. And so this phenomenon really proliferated in the years after that. So I think that's the reason.
I remember,
so it's a basically new phenomenon.
I remember when Chris Van Hollen filed his lawsuit on this issue, and I agree with everything you had to say right up until you concluded that for those reasons we shouldn't move forward. I think we ought to worry deeply about the institution, and for those reasons we ought to move forward. It's incredibly troubling to me as a 3-year member that Congress could pass a statute that says primarily, and the IRS could introduce regulations that say substantially, and that's just going to be the end of the discussion, and we're not going to come back and revisit that for 40 years. It is undeniable that in my lifetime, this is the most distrustful I have seen my constituents of the IRS, but because of that still unfolding 501c4 issue. Have you, since '87, seen a time, maybe that's just my limited window, have we seen a time where the public's trust in the IRS has reached a point lower than it is today in the time you've been with the committee?
I'm not sure. I think it's gone up and down. But remember, the distrust of the institutions include this one.
Sure.
And I think we need to be concerned. And that's why I think this legislation only makes it worse, but I've expressed myself.
To you and Dr. Bustani's credit, ordinarily what I expect to see when a piece of legislation shows up in front of the Rules Committee is the Committee of Jurisdiction saying, we're the smartest guys in the room and we're going to tell you exactly how to solve the problem and do it our way because we got it right. But that's not what the Ways and Means Committee did this time. This time the Ways and Means Committee said this is still an issue around which there is a great deal of passion on both sides of the aisle, and so let's just take a 1-year break, and at the end of 1 year, this moratorium will go away. And I don't know what the discussion was, Dr. Bustani, on that great deal of restraint, but when folks say are you guys doing partisan things in Washington? I could imagine that case being made if we'd said this is the Republican solution to this issue, and this is the way it's going to be in perpetuity. But you all didn't. You said let's just take a break. We need to deal with it, but we don't have the credibility with it within the Treasury Department right now to deal with it. Is that?
That's true. And let me point out that before all this broke with the allegations, my intent as chairman of the Oversight Subcommittee was to actually launch a series of investigative hearings into the tax-exempt sector, because that area of law had not been looked at in quite a long time. And we held a number of hearings, and I had plans to continue to do so. We even had discussions about looking at 501c4s, what's working, what's not working, what are the problems, what are the concerns. But then we, of course, had to veer into this investigation, which has taken on some political overtones. But the fact is, we need to continue this. We need to complete the investigation, and we need to take a long, hard look at the tax-exempt sector across the board. It's a very complex area of law. There are many different types of organizations. And so you're correct. The chairman exercised restraint, exercised the prerogative of this institution by saying, wait a minute, we're not going to let the executive branch rush off and institute a regulation until we've done our thorough investigation and we do our due diligence. And so I think it's a prudent approach.
Let me just be clear. Regulation on the books since 1959, and your position is we absolutely positively have to take a look at it, and we absolutely positively want to take a look at it, but we want to do it together in Congress rather than let the administration do it alone.
That's correct. And Mr. Levin's comments, my friend Mr. Levin, is correct. A lot of money is has been put forth through these organizations. We've seen an escalation, not only in 501c4s, but in other areas of the tax-exempt sector. And so we need to look at this area of law. It's complex. And my position is in agreement with Chairman Camp. Let's take a step back, stop this rulemaking process for 1 year, and let's continue our investigation.
I thank you both. I yield back, Mr. Chairman.
Chairman yields back his time. Gentleman from Orlando, Florida is recognized. Gentleman has no questions. Gentlewoman from Florida is not seeking time. Gentleman from Texas, Dr. Burgess.
Thank you, Mr. Chairman.
Gentleman's recognized.
Thank you. I just have a couple of follow-up items. Number one, in answer to the question of Lois Lerner, she retired in September of last year. My understanding is she retired with full pension of almost $100,000 or a little over $100,000 a year. I don't know, Mr. Levin, if we know the disposition of any of the other people whose names came to light over the past year. I mean, your committee talked about an accountability review board, and they produced a report, but are you aware of any other individuals within the agency who have been disciplined as a result of this?
The acting commissioner also resigned.
Correct. And as I recall at the time of that resignation, he said his time was limited anyway. So whether he was forced out or not, it remains an open question. But you had the individuals in Cincinnati. You had a lawyer in Washington, D.C., Carter Hull, who was just directing those employees. What has been the disposition of those individuals? Are they still on the payroll and still at work? Do the taxpayers still have to be concerned about their activities?
I'm not sure in each case, but we have been looking into this for a long time, and the investigation will continue. As I said, so far there has been no evidence of any political involvement. There's been zero. And I think that's why it's unwise to politicize this now. It's unlikely the regulation could come out with all of these inputs. But look, I appreciate the chance to have said my piece.
Well, I just certainly want to concur with other members that I've heard on the Rules Committee who have said they see great value in taking a step back rather than enforcing new regulations. Still don't have a clear understanding of all of the moving parts and what went wrong. Don't have a clear understanding of who's been held accountable. and what measures will be used in the future. So I would favor the taking a step back before the agency comes up with additional regulations. And I got to tell you, Mr. Levin, it's been said already in this hearing today. This is an agency which no one likes because it's the IRS. They collect our taxes. Who likes the IRS, man? No one does. At the same time, it is imperative that they maintain their credibility, their trust with the American people, because they are the tax collector. They're the ones that hold the keys to the kingdom. They can take it under force of law, the fruits of our labors, to spend for goodness knows what by the United States Congress. So people must have an underlying faith in the agency, and right now they do not have it. Were I the president, I would have demanded an investigation by an impartial body, a special prosecutor who had full authority to bring a case in federal court. I appreciate what the committee's work has been to this point, trying to get the answer to these, but as we've heard testimony today, it's painfully slow, and the answers are slow in coming. But if I were the president, and recognizing how important this agency is over and above almost any other agency under his control, he has to establish that basic trust. Because come April 15th, we're all going to be writing our checks to the IRS, and if that trust isn't there, what prevents any tax attorney in this country from going into tax court and saying, prove to me that your agency did not target my client? The voluntary compliance with the income tax system in this country is actually much more at risk than you realize right now. And I think it would be imperative on not just the Congress, but the executive branch as well, to get this figured out and get it done now.
Let me just respond, if I might, briefly. There is a criminal investigation underway. The President did what he should do. He very much made it clear how inappropriate were the actions that were taken. And a criminal investigation is underway.
Well, Mr. Levin, with all due respect, the credibility of the Justice Department right now is not at an all-time high. An independent investigatory branch, I think, would go a long way towards restoring the public confidence in this agency. Mr. Chairman, I thank you for the consideration. I'll yield back.
Chairman yields back his time. I want to thank both of you, and I would say that I think that notwithstanding you heard a lot from probably Texans in this endeavor, but I hope other members also that offered a comment to you, that this committee does welcome you to both be here today. This committee is looking forward to both of you coming back, and we will very much appreciate your hard work on behalf of not just the taxpayers, but also the committee and what you do. And I believe both of you equally said this investigation is important. It should be completed. It needs to be done correctly. We wholeheartedly support that. I want to thank both of you. You're now both excused, and thank you very much.
Thank you very much.
Yes, sir. I'd now like to call upon Ms. Lujan, who would wish to testify for H.R. 3865. If the gentleman will come up, and please remember that the microphone is there for your use and purpose, and we hope that I know you got a soft voice. Yes, ma'am. And that you'll pull it close to you and we can hear you without objection. Anything you have in writing will be entered into the record. The gentleman is recognized.
Thank you, Mr. Chairman, and thank the ranking member and all members of this committee for this opportunity to testify. And I have to tell you that this is my second time before this committee, Mr. Chairman, and first time you were very kind at my inaugural testifying event. But I have to say, in all the years I've testified before a number of bodies, no one has ever said that I have a soft voice. And so I take that as a grand compliment. Thank you very much.
Take it, you have an enchanting voice also.
If it works for my amendment,
the land of enchantment.
Mr. Chairman.
The land of enchantment.
True enough. I thank you very much. Yes, so my amendment would simply, I think, take away this entire debate about whether or not there should be rulemaking, whether we should delay that. I think that we should go back to the intention made by Congress in 1959, which says exclusively, which is my reading, that these social welfare organizations, or these 501c4s that are subject of many measures, and I heard the lawsuit, Van Hollen's lawsuit referred to, that this subject matter really is that arbitrarily, we have the IRS and Department of Treasury making rules that suggested that it doesn't have to be exclusive. And we find ourselves then today, particularly after Citizens United, that clarifies that it's not just political activity that was, I think, cloudy between our 1959 legislation and how that was being interpreted. And then with Citizens United in 2010, it's very clear that corporations can engage directly in political activity, and you saw a proliferation then in undisclosed, non-transparent, non-related, tax-exempt activity by 501c4s. It seems to me that the best thing to do is to adopt my amendment, which then requires that 501c4s, to keep that tax-exempt status, must do exactly what Congress intended, that they should exclusively do the work of social welfare organizations. And it would no way limit any of the other activities that they can do by virtue of being a social welfare organization. And Mr. Chairman and committee members, it deals then with both problems, that the IRS doesn't really know what is and isn't political activity, and that the IRS doesn't know what constitutes what percentage based on the amount of revenue that a 501c4 or any of those organizations are bringing in and what they're spending it on. And so again, I'm probably spending far too much time on what my amendment does, but it just requires that we go back to the original intent of that law, which then I would hope would make it very clear to the Department of Treasury and the IRS about exactly what they should do with these charitable organizations.
Thank you, gentlemen. The gentlewoman said corporations are making these are engaged in this process. Is that right?
Mr. Chairman, I think, can you clarify what you mean by engaged in the process?
I'm just using, you said corporations.
Well, that Citizens United made clear that corporations can directly contribute and and engage in political activity, that's their First Amendment right. So one of the contradictory aspects about what 501c4s are doing is that they're, by virtue of the allowance to use 49% or so, something under 50% engaged in political activity, that now corporations can donate directly to a 501c4. That 501c4 can engage in something totally outside that social welfare. So let's say it's the Cancer Society can engage in a very non-health related political activity, and those donors are not disclosed, and there's no transparency in that process. And so what I meant by the Citizens United decision is that it created through 501c4s a new vehicle that didn't really exist before. You had much more limited political activity until the Citizens United decision. But either way, it wasn't consistent with what Congress passed in 1959, which is the exclusive work of those tax-exempt organizations was for that social welfare purpose under a 501c4.
Well, I hope we don't want to go back to silencing people. I thank the gentleman from Utah is recognized. Gentleman has no question. Gentleman, Chairman from Oklahoma. Gentleman, does any member of the committee have a request for any time for the gentleman? Gentleman from Georgia recognized.
Thank you, Mr. Chairman. My only question was, would you support that same kind of restriction being added to the 501c5 section that participating in and intervening in political campaigns on behalf of or in opposition to candidates would be prohibited? I happen to share your concerns that, for Pete's sakes, why it's taken us 50 years to get around to dealing with this is a strange one to me, and I'm glad folks are new and focused on it. But it does, thinking about that mistrust, it does strike me as odd that we're spending so much time talking about all of the money that's involved in 501c4s, which is in fact troubling, and we're not spending any time talking about all the money that's involved in 501c5s, which is also troubling. And I didn't know if you might. I know it wouldn't be germane if you were offering a C5, but I just wondered if you would agree that needed attention as well.
Mr. Woodall, I appreciate your raising that issue. I mean, my basic approach here is that we should be treating them much like their original purposes intended, because I don't believe we would, and I'm going to refer back to a statement the chairman made. We're not silencing anyone. There are organizations. You can set up a political organization or a PAC. That's very clear, and you have every right right to donate and contribute money for that purpose. And so we have those opportunities. I just think all of the tax-exempt organizations should have to behave in a way that's completely consistent with that authorizing event. And so it's very likely I would support that, Mr. Woodall.
I thank you very much. Thank you for bringing this amendment today. I yield back, Mr. Chairman.
Gentleman yields back his time. Gentleman, Massachusetts recognized.
Again, I don't think we should be bringing this bill to the floor to begin with, but if we're going to bring it to the floor, we ought to allow people to offer amendments, so I certainly would support your amendment being made in order. Yield back my time.
Gentleman yields back his time. I don't see any other member that seeks time at this time, and thank you very much. I want to thank you for taking time. So your conclusion now?
Again, I would ask for your support of my amendment because I think that it does exactly what the bill that's being offered does, which is it makes sure that we don't have arbitrary rulemaking. It makes very clear that when Congress passes a law that we should follow that law the way that is intended, and it would stop the proliferation of, I think, political activity that's not appropriate in the context of these tax-exempt organizations. And with that, Mr. Chairman, I yield back.
I thank the gentleman for taking time, and her second trip was very successful also, at least I think, and I want to thank you for taking time. Gentlewoman, if she has anything in writing, would be please give that to the clerk at this time.
Thank you.
Gentlewoman is now cleared, and thank you for.
Thank you, Mr. Chairman.
This now closes the hearing portion on H.R. 3865. I'd now like to open up the hearing portion of H.R. 2804. Would like to welcome to the table the gentleman, Mr. Collins from Georgia, representing the Committee on Government Reform and Oversight, the gentleman from Committee on Judiciary, Chairman Goodlatte, the gentleman from Pennsylvania. I don't know if this is Mr. Cartwright's first time or not for the Rules Committee, but welcome. I appreciate you coming a few minutes early to see how much fun we have up here. And the gentleman, Mr. Johnson, from Georgia, and would thank all four of you for taking time to be here. Mr. Goodlatte will let you share that mic with him. He's really good at this stuff. By the way, you want to watch a pro, you're sitting right next to one. So I'm delighted that you're Mr. Cartwright. Without objection, anything that any of the gentlemen have in writing will be entered at the record, and I would appreciate all of you being here. Mr. Collins, I'm going to defer to you first for an opening statement, anything you wish to speak about. Gentleman's recognized.
Thank you, Mr. Chairman. I think the committee, and I think the process we have here, and I think the bills that are coming forward that are being shared through this H.R. 2804 is something that needs to be worked on, and I just appreciate the chairman, the ranking member, and the members of this committee for being able to hear this today. It's an honor to be here with this. Also, in regard, also want to speak on in praise of Mr. Holding from North Carolina, who is the principal sponsor of H.R. 2804, the ALERT Act, and it creates the needed transparency in the regulatory process by requiring agencies to submit monthly updates on expected regulatory action in the upcoming year. Unfortunately, today, regulatory transparency is sorely lacking. Small businesses, citizens, advocacy groups must rely on agencies' annual regulatory plans and the semi-annual unified agenda to prepare for upcoming regulations. Under this administration, deadlines for issuance of these regulatory transparency planning tools have been delayed or skipped entirely, leaving citizens and impacted stakeholders in the dark. In the fall of 2012, the Oversight and Government Reform Committee and the Judiciary Committee wrote 2 letters to the acting administrator of the Office of Information and Regulatory Affairs requesting an explanation for why the spring unified agenda was not yet published. In addition to completely skipping the spring edition, the fall 2012 edition was published months late. Congress never received an adequate explanation as to why the administration, this would be failed to be published. The ALERT Act codifies the requirement that agencies must inform the public of upcoming regulatory plans and provides the important motivation for federal agencies to comply with these minimal transparency requirements. Without regulatory transparency, the public is unable to evaluate or prepare for agencies' anticipated regulatory activities which, by the way, to this committee cost billions of dollars. Last year alone, this administration published rules creating $112 billion in regulatory costs. In the last 4 years, regulatory costs approached $500 billion. The ALERT Act requires monthly updates so that the public will have up-to-date information about anticipated regulatory activity, providing the opportunity for meaningful participation in the regulatory process, and to ensure that this administration and future administrations do not shirk their responsibility, as has been the case in recent years. The ALERT Act prevents regulations from going into effect unless the monthly updates have been submitted for at least 6 months. I'm pleased to support the ALERT Act because it restores much-needed accountability and transparency to our nation's regulatory framework, and I appreciate the committee's time and look forward to floor consideration and eventual adoption of this common sense legislation, and happy to answer any questions about that.
Mr. Collins, thank you very much. Mr. Cartwright, I want to welcome you to the Rules Committee. On behalf of the Government Reform Committee, I know that you and Mr. Collins have an opportunity to present this piece of legislation here today, and I would ask that you go ahead and grab that mic from the gentleman, the chairman of the committee. He'll punch the button for you there. We'll make sure we hear from you. Gentleman, Mr. Williams is now recognized.
Thank you, Mr. Chairman, and thank you all members of the committee. I appreciate the opportunity to testify here this evening on about H.R. 2804, the ALERT Act. The bill is being brought to the floor during this week, which has been labeled the Stop Government Abuse Week. Certainly this bill does have some stopping power, but it would not stop so-called abuse by the government. What it would stop is the government doing its job, protecting our health and safety by helping to grind the regulatory process to a halt. Mr. Chairman, I'm going to address Title I of the anti-regulatory package, which includes the text of the All Economic Regulations Are Transparent Act. Now, this legislation is unnecessarily burdensome for agencies. Agencies are already required to provide status updates twice a year on their plans for proposing and finalizing rules pursuant to the Regulatory Flexibility Act and Executive Order 12866. And, Mr. Chairman, if you haven't had a chance to review Executive Order 12866, it is extremely onerous on agencies. It's hard to believe they can get anything done at all, but they are complying with that already. This legislation would require agencies who are doing that, or which are doing that twice a year, to do it monthly. But the most troubling part in Title I is the part that would prohibit agency rules from taking effect until the Office of Information and Regulatory Affairs has posted the information required by the bill online for at least 6 months. Now, this moratorium can only be avoided under this bill if the agency claims an exception from the notice and comments requirements of the Administrative Procedure Act, or if the President of the United States issues another executive order. Therefore, it delays most regulations by an additional 6 months. I think we can all agree that transparency in the rulemaking process, just like transparency in money and going into government, is a good thing. This bill, however, sacrifices common sense in the name of improving transparency without achieving meaningful transparency. Agencies already make significant amounts of information available during the rulemaking process on the website regulations.gov. And for heaven's sakes, for decades and decades and generations before websites came up, rulemaking was going on without objection like this. Now, regulations.gov carries all of this stuff online for anybody who wants to look at it. This bill could simply require agencies to make additional information publicly available on that website, but it doesn't do that. Under this bill, an agency could post information about the cost of a proposed rule on its own website for a whole year. But if the administrator of the Office of Information and Regulatory Affairs didn't post that same information for at least 6 months on a separate website, the agency would be prohibited from finalizing the rule. So, Mr. Chairman, I submitted in committee an amendment to the committee for consideration that would strike the moratorium provision in Title I. Now, striking that provision would ensure that an agency rule will not be needlessly held up because the Office of Information and Regulatory Affairs didn't post a piece of information online for the required exact 6 months. I have been assured by the Congressional Budget Office that my amendment is revenue neutral. And so I would respectfully urge this committee to adopt an open rule for H.R. 2804. If the committee instead chooses to adopt a structured rule, I would ask that my amendment be made in order. I would also urge the committee to make as many amendments in order as possible in order to allow members adequately to debate both the intended and unintended consequences of this bill. Thank you, Mr. Chairman. I yield back.
Mr. Cartwright, thank you very much for your testimony. I'd like to now defer to the gentleman, Chairman of the Judiciary Committee, Mr. Goodlatte, for him taking time and giving testimony on 2804. Gentleman is recognized.
Thank you very much, Chairman Sessions, and to the members of the committee. I appreciate the opportunity to testify today. I will summarize my statement, put it in the record in its entirety. H.R. 2804 was introduced by Mr. Holding of North Carolina, and the proposed rules print of the bill incorporates additional regulatory reform legislation introduced by the gentleman from Georgia, Mr. Collins, as well as the Regulatory Reform and Commercial Antitrust Law Subcommittee Chairman Backus and myself. These four important bills are brought together under the new title of the Achieving Less Excess in Regulation and Requiring Transparency Act of 2014, also known as the ALERT Act. Mr. Chairman, the need for this legislation to help create jobs and achieve full economic recovery is clear. Just over 6 months ago, President Obama announced that he would once again pivot to the economy. The bottom line of his speech: after 4.5 years of the Obama administration, we're not there yet. The President was right. We were not there yet, nor are we there today. Job creation and economic growth continue to fall short of what is needed to produce a real and durable recovery in our country. The nominal unemployment rate is down, but that is not because enough workers have found jobs. It is because so many unemployed workers have despaired of ever finding new full-time work. They have either left the workforce or settled for part-time jobs. As long as this situation continues, Congress must stay focused on enacting reforms that will stop the losses, return America to prosperity, and return discouraged workers to the dignity of a good full-time job. The legislation we consider today is just that kind of reform. Through its strong common sense measures, the ALERT Act will powerfully and comprehensively reform the federal regulatory system, from how regulations are planned to how they are promulgated and to how they are dealt with in court. This is legislation that Congress cannot pass too soon. Let me give you some statistics. These new burdens come on top of an already staggering cumulative burden that has grown remorselessly over the decades. The total cost of federal regulation to our economy now reaches an estimated $1.86 trillion. That burden is burying America's job creators, workers, and families. It equals roughly $15,000 per U.S. household, 11.5% of America's GDP in 2012. It is more than $300 billion higher than combined individual and corporate federal income taxes, and equals 85% of U.S. corporate profits in 2013. Let me give you one example from my district. Mr. Bob Sells, one of my constituents and president of the Virginia-based division of a heavy construction materials producer. His company and its workers were harmed by EPA cement kiln emission regulations that were technically unattainable and included provisions vastly changed from what the EPA proposed for public comment. Other EPA emission regulations that were stricter than needed to protect health, gerrymandered to impose expensive controls on other types of emissions, and prohibited common sense uses of cheap and safe fuel that could actually help the environment. And the Department of Transportation regulations that, without increasing safety, vastly increased record keeping for ready-mix concrete drivers, unnecessarily limited their hours, and suppressed their wages. Title II of the ALERT Act helps to protect people like Bob Sells and his workers from regulations that ask job creators to achieve the unachievable, do not help to control their stated regulatory targets, suppress hours and wages for no good reason, and inundate Americans with unnecessary paperwork. I have another example here as well, but in the interest of time, I will submit that to the record and simply urge the members of the committee to report H.R. 2804 to the floor.
Without objection, the gentleman's entire statement will be entered to the record. I thank you very much, Mr. Chairman, for being here. I am delighted, Mr. Johnson, that you're here and the gentleman's recognized.
Thank you, Mr. Chairman. It's always good to be back before you. Mr. Chairman, I come today to speak in opposition to H.R. 2804, the All Economic Regulations Are Transparent Act of 2014, and in support of my amendment to grow the economy and protect jobs. The ALERT Act purports to ease the burden of regulations on American businesses. We can all agree that fostering growth and confidence among small businesses is a worthy goal. Small businesses are an engine of the American economy. They drive innovation, create opportunities and jobs, and form the backbone of the American dream. But, Mr. Chairman, we cannot pretend that the ALERT Act would grow the economy, help small businesses, or create a single job. Without question, the only purpose of this bill is to straitjacket the rulemaking process that protects countless Americans every day. The result of this bill's disastrous approach to policy making would be an inefficient, wasteful, and dangerous regulatory process. Title I of the bill imposes a 6-month moratorium on rules. The rulemaking process is already transparent, deliberative, and exhaustively inclusive of all the views of small businesses and other interested parties. Adding an additional 6 months to this process would do little except create confusion and increase compliance costs. Instead of cutting through red tape, Title II of the bill would add over 60 additional procedural and analytical requirements to rulemaking. If making government more efficient is the goal, then I have some bad news. This bill is taking us backwards. This is yet another clear message that this bill would lengthen, not shorten or streamline, the rulemaking process, thus undermining the regulatory certainty and predictability that small businesses rely on to make long-term decisions. And in case the first two titles didn't adequately convey the message that this bill is only designed to create regulatory mischief and confusion instead of offering serious solutions, Titles 3 and 4 would authorize virtually any party under the sun to challenge a proposed rule or intervene in litigation in federal court, no matter their connection to the underlying controversy. By giving a hand out to well-funded organizations to challenge proposed rules, consent decrees, and settlement agreements at every opportunity, the ALERT Act would stack the deck against the public interest and the American taxpayer. And who would be harmed by this deregulatory train wreck? Every American who wants their air to be clean and breathable. Every mother who wants safe formula for her baby and cribs that don't collapse on the baby in the dark of night. Every small business competing for an edge in a marketplace dominated by large, well-funded competitors would suffer if this bill were to pass. And the list goes on and on. The truth is that we all benefit from a government that works in smart, efficient ways to keep our food, water, other products, keep our jobs and our medicines safe. Mr. Chairman, Americans want real solutions to growing the economy and creating jobs. They look to the House of Representatives for leadership, not messaging bills. That's why it's so critical that my amendment be adopted to protect Americans' opportunities in the workplace. My amendment would exclude from any bill any rule, consent decree, or settlement agreement that would result in net job creation or have greater benefits than costs. I would hope that my friends on both sides of the aisle would have the desire to improve the economy and take actions to foster job growth. I urge that this committee support job growth by making my amendment in order, and at this time I will wish you all a happy Stop Government Abuse Week. And thank you, Mr. Chairman, and I yield back the balance of my time.
I thank the gentleman for his comments and for the panel for the hard work they're doing. I would yield to the gentleman from Utah.
Could I just say to Mr. Collins, first of all, you don't realize this, but the last time we talked, you gave me the opening statement I have in every one of my Lincoln Day dinner speeches I've been giving this last couple of weeks. So I want to thank you for that. You don't know what you did, but it's the one-liner that gets the biggest laugh. Secondly, as far as your provision that's in this bill, I just want you to know, as far as the Western State Caucus is concerned, your provision is one of the bills we identified as a must, one of the most important ones for all of us who actually live in the West. And in fact, we had a bill on the floor last week. 2 sections of that bill would have been needless had your bill and your provision already been in place and worked ahead of that time. So especially when it comes to land policy, it is essential, and especially when this government owns 1/3 of all America. The land policy is made by legislators, not by the court system. And that's, I think, what goes, at least from the perspective of those of us in the West, that goes to the heart of what you were trying to do with that particular bill, where decrees are made and decisions are done, and as you were right, then oftentimes regulators will then come back to us, or land managers will come back and say, we can't do anything about it because the court made us do it. When indeed the court never made a decision on that. It was done out of court ahead of time. In addition to that, we need to go one step further. We do not even know what the cost of these are and how many decisions are being made, who is getting relief from the federal government in exchange for these things, for attorney costs. That's another piece of legislation that there is another Western member that has in your committee. I'd like to see that go forward as well, so we at least know how much these are costing the taxpayers when they go through these types of court cases. But I want to thank you specifically for that, because it's something that is of critical importance to the West, where we are the so-called land states of this country. And thank you for the one-liner you didn't know you gave me.
Any way I can be of help to you or the committee is good. I think one of the things you bring up is it's been said, one of the more and frankly disingenuous arguments against the sue and settle piece of this bill is that it takes away inclusiveness. Really, the consent decree is what takes away the inclusive and transparency, and I appreciate your comments.
There are example after example after example of how this has actually happened, and to the detriment of a lot of people. So thank you very much. Yield back.
Thank you, Mr. Chairman. I thank everybody for being here. It's frustrating, again, to be considering a bill that's not going anywhere. The previous bill, the administration is going to veto. This one they're going to veto as well. And I would like to ask unanimous consent to put into the congressional record the statement of administration policy on this. And again, I would just urge my Republican friends here to plead with your leadership. We ought to be, you care about jobs, we ought to be increasing the minimum wage. You ought to make sure that we have an equal pay for equal work bill. We ought to pass a comprehensive immigration reform. And God forbid we try to pass a highway bill, but your side can't agree on any of the pay-fors. That put millions of people back to work. But we ought to be doing things that are going places that actually the American people want us to deal with. And this to me is filler. And we have an opportunity. We're in session so very little under this leadership. It'd be nice if that we made sure that every day was actually worth it. We're actually doing something to move the ball forward. It is frustrating, I think, for people on both sides of the aisle to go home and say to the American people, we've accomplished absolutely nothing. And I think that's what we're doing today, and I yield back the balance of my time.
Gentleman yields back the balance of time. Appreciate anyone seek recognition. Mr. Cole? Gentleman does not seek recognition. Gentleman from Florida. I thank the gentleman. It's good to see you, Alcee. Hope you're doing all right today. Thank you very much. Does any other member of the committee seek to be recognized at this time? Seeing none, I want to thank all four of you. I recognize that all four of you, including Mr. Collins, spent a good bit of time watching this committee today. This committee is a hard-working committee. We work on behalf of all the members. You're always welcome in this committee, Mr. Cartwright, and I think you did well enough to get invited back. But it's my hope that you will, anything you have in writing, that you'll leave for the gentlewoman who is here with us this evening, the stenographer. And I want to thank all of you. You're now dismissed. Thank you very much. Ready to go? Yeah. Okay, you ready? Okay. This closes the hearing portion of H.R. 2804, and the chairman will be in receipt of a motion. Thank you very much. Gentleman, Utah is recognized.
Mr. Chairman, I move the committee grant H.R. 3865, the Stop Targeting of Political Beliefs by the IRS Act of 2014, a closed rule. The rule provides 1 hour of debate equally divided, controlled by the chair and ranking minority member of the Committee on Ways and Means. The rule waives all points of order against consideration of this bill. The rule provides that the amendment in nature of substitute recommended by the Committee on Ways and Means, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of orders against provisions in the bill as amended. The rule provides 1 motion to recommit with or without instruction. Section 2 of the rule provides for consideration of H.R. 2804, the All Economic Regulations Are Transparent Act of 2013, under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of this bill. The rule makes in order as original text for the purpose of the amendment, an amendment in the nature of substitute consisting of the text of the Rules Committee print 113-38, and provides that it should be considered as read. The rule waives all points of order against the amendment in the nature of substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by the member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided, controlled by a proponent and opponent, shall not be subject to amendment, and shall not be subject to amend for division of the question. The rule waives all points of order against the amendment printed in the report. The rule provides 1 motion to recommit with or without instructions. Finally, Section 3 of the rule provides that it shall be in order at any time on the legislative day of February 27, 2014, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15 relating to H.R. 3370, the Homeowners Flood Insurance Affordability Act. So moved.
Now heard the motion from the gentleman from Utah, and I would defer to the gentleman from Georgia for an explanation of the rule. The gentleman is recognized.
Thank you, Mr. Chairman. The rule provides for a closed rule for the IRS bill, but makes 11 amendments in order for the OGR and judiciary language, including amendments offered by both of the witnesses who testified here today. It includes the motions to recommit, as we believe is the right of the minority, and provides that suspension authority for Thursday in case it is necessary. I yield back.
Thank the gentleman. You've now heard the motion and the discussion. Is there any amendment or further discussion? Gentleman from Massachusetts.
Mr. Chairman, I have an amendment to the rule. I move the committee grant H.R. 2804 and H.R. 3865 open rules so that all members have the opportunity to offer amendments to these bills on the floor.
Now heard an amendment by the gentleman from Massachusetts. Further debate or discussion on this? Seeing none, those in favor of the Montgomery amendment signify by saying aye.
Aye.
Those opposed, no. No. Noes have it. Noes have it. Is there further amendment or discussion? Seeing none, the vote will now be on the motion presented by the gentleman from Utah. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it. The ayes have it.
Well, Mr. Chairman, on that I have to ask for a recorded vote.
Gentleman asked for a recorded vote. Clerk will call the committee.
Ms. Fox.
Aye.
Ms. Fox, aye. Mr. Bishop. Mr. Bishop, aye. Mr. Cole. Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Nugent. Mr. Webster. Mr. Webster, aye. Ms. Roslainen.
Aye.
Ms. Roslainen, aye. Mr. Burgess. Mr. Burgess, aye. Ms. Slaughter. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 2 nays.
Motion is agreed to. Motion is agreed to.
It sounded a lot closer.
It did sound that way. I will admit that.
You're in a good mood tonight.
I would like to advise the committee that the gentleman, Mr. Woodall, will be handling this for Republicans.
And Mr. Polis for the Democrats.
Mr. Polis for the Democrats. The next meeting is scheduled for the Rules Committee at 3 p.m. tomorrow on H.R. 899. We have an exciting presentation of a bill. Dr. Fox will be bringing forth the Unfunded Mandates Information and Transparency Act of 2013. Is there further discussion for the committee? I want to thank each of you for being here this evening and hope you have a wonderful day back. We're now finished with our hearing for the day.